This program is brought to you by Emory University.
We're now going to step into our corporate panel, which this year will be about choice of law in Chapter 15 avoidance actions. So Chapter 15, of course, came along with BAPSIPA as Judge Deal discussed, and we have some very fantastic panelists with us to discuss this issue. Excuse me just one second, gonna get set up. I would like to now introduce the panelists, and I think that they will have some very insightful words on this topic. So first, she is a restructuring associate in the New York office of Kirkland & Ellis, LLP, and a graduate of NYU Law School. She has been involved in Chapter 15 matters representing creditors, as well as various Chapter 11 matters from both the creditor and debtor side. I could please welcome Amine Bordi. Thank you so much for joining us today, Ms. Bordi. It's a pleasure to have you. Next, he is a director at the Bayard firm in Delaware and co-chair of the firm's Business Restructuring and Liquidations Group. He has more than 25 years of experience in the restructuring field, and he has participated in many of the largest and most complicated business reorganizations, liquidations, and distressed sales and acquisitions in Delaware's state and federal courts. He has also experienced in out-of-court restructurings and workouts and has appeared in many bankruptcy jurisdictions across the country. Please welcome Mr. Scott Cousins. Thank you so much, Scott. We can't wait to hear from you. She is the chair of Ackerman's Bankruptcy and Reorganization Practice Group, a nationally recognized team serving as bankruptcy counsel or receivers in many of the largest bankruptcy filings in the United States. She counsels clients in the financial services, real estate, hospitality, restaurant, and retail sectors on business reorganizations and liquidations, assumption and rejection of leases, workouts, debt restructurings, assignments for the benefit of creditors and creditors' rights, and has substantial experience with fraudulent conveyance and preferential transfer litigation. Please welcome Ms. Andrea Hartley from Ackerman LLP. And finally, she is a partner in Castles Brock's Restructuring and Insolvency Group. As a former U.S. practitioner, her strength is in working with U.S.-based clients to understand the challenges of the Canadian insolvency landscape and developing solutions in complex proceedings. Her practice focuses on corporate restructurings with an emphasis on debtors, DIP lenders, and informal committees in cross-border proceedings. Her restructuring matters encompass a variety of industries, including mining, oil and gas, renewable energy, manufacturing, and entertainment. Please welcome Ms. Natalie Levine. Thank you all for coming down and joining us for this panel. And we're actually going to start with a short refresher on Chapter 15. It is an interesting area of practice that will only continue to grow as our world continues to shrink. And more international companies rely on assistance from U.S. bankruptcy courts. So I'm just going to start this off by going through this. So I've prepared a short, abbreviated version of the PowerPoint slides that are in your materials. And I'd like to just go ahead. So Chapter 15, Choice of Law. So a quick overview. So as I said, Chapter 15 was created under BAPSIPA, became effective in October of 2005. It's based on the UN Citral Model Law on Cross-Border Insolvency, and it has 41 adopting countries. Its purpose is to provide effective mechanisms for dealing with cases of cross-border insolvency. It has multiple objectives, but the main focus of these objectives is promoting comity between different international courts and insolvency systems. So basically what's going to happen in a Chapter 15 case is a foreign representative is going to file an ancillary case in the United States, and you have to do that, you have to prove the existence of a foreign proceeding and your authority as a representative. You can either have a foreign main proceeding or a foreign non-main proceeding, and these turn on the center of main interest. Now, in the foreign main proceeding, the debtor's center of main interest will be located in the country where the foreign proceeding is occurring. And in a non-main proceeding, the debtor will have an establishment, but the center in the forum where the proceeding is being handled, but the center of main interest of that debtor is elsewhere. So this center of main interest, if you were thinking that it might be defined, you would be mistaken. It's naturally, as with many other terms in the code, it is undefined, but the presumption is that the center of main interest is in the country where the debtor's registered office is located. However, that presumption is not dispositive. Factors include the location of their headquarters, the location of management, the location of the majority of creditors, and the applicable law of most of those disputes. The big case on this is Emory Suntech Power Holdings Company. So now we'll turn to avoidance actions. When you file a Chapter 15 case, a court can apply either U.S. law or it can apply foreign insolvency law. So, for example, you could apply the law of the forum where the debtor's center of main interest is located, and in this case, you would most likely use that forum's avoidance provisions. So how do you choose which to apply? So this is going to be a little bit more of a theoretical background before we get into some of the practical experiences of our panelists. So there's two main tests, and they are the law of the forum and the center of gravity. The law of the forum's main advocate is Professor Jay Westbrook at the University of Texas. He's a prolific writer and scholar in Chapter 15 and cross-border insolvency generally. The center of gravity and the center of gravity test, the other test, has been upheld in several judicial opinions. So the law of the forum, where you want to be really fancy, lex fori concursus. Basically, the rule here is that the law of the forum in which the case is pending should control. Professor Westbrook also calls this the home country rule. Usually this means that whatever the debtor's home country, that insolvency law is to be applied. Only a couple of notable cases have applied this test. The really seminal one is Fogarty versus PetroQuest Resources Incorporated in the In re Condor Insurance bankruptcy. And that was decided at the Fifth Circuit. The other one is In re French, which was decided at the Fourth Circuit in 2006. Since it's the seminal case, I'm going to go through a little bit of the facts of Fogarty. So the Fogarty case dealt with an attempt by the foreign representative in the insolvency proceeding of Condor Insurance, an insurance company based in Nevis, to recover a lot of assets that had been fraudulently transferred pre-petition from Condor Insurance to Condor Guarantee. The foreign representative wanted to apply Nevis law to the proceeding, as U.S. law under Chapter 15 generally prohibits pre-petition avoidance actions. And the Fifth Circuit decided that it was going to apply Nevis avoidance action rules to the proceeding based on considerations of comity and statutory construction. Basically, Chapter 15 stated purpose is promoting cooperation, and in that light, the court looked to that and decided to apply this law of the forum test. Now, I know I believe Ms. Hartley told me that one of her former partners actually handled part of this case. So if you have any thoughts on that, would you mind discussing that with us?
Sure. Actually, it's my current partner, David Parham, but he wasn't a partner with Akerman at the time. He was with Baker McKenzie when he argued this, but we spoke a little bit about it, and I know Jake will probably go into more detail, but interestingly, the case was filed, the Chapter 15 was filed in Mississippi. It's where they thought the targets were located, the bad guys, as well as the assets, the $313 million. So that's how they selected their forum. I know that's some other issues we're going to talk about. And as Jake may go into in more detail on his slides, the court held that while it is plain that relief under the listed sections, and then it's referring to section 1521A, that it's stating that while it is plain that relief under the listed sections is excluded, the statute is silent regarding proceedings that apply foreign law, including any rights of avoidance such law may offer. And of course, that ultimately ended up being the holding in the case. Unfortunately, it took so much time to have this decision through the appellate process, but that by the time it got ruled on and they were able to proceed, the $313 million in assets had dissipated. So.
Thank you so much.
Sure.
It's always interesting to hear from someone who's is related to these seminal cases. So second, a particular section 1521A7 provides a long list of prohibited avenues of relief, including a foreign representative can't pursue U.S. Avoidance actions under U.S. law. It does not, however, include a restriction on applying the avoidance action law of the foreign proceeding. So the court applied the canon of expressio unius est exclusio alterius, stating that where there are enumerated exceptions, additional exceptions are not to be implied in the absence of a contrary legislative intent. And combining that consideration of comity with statutory interpretation, the court applied Nevis law. So this is probably the biggest victory in favor of the law of the forum. So now we're going to move to the center of gravity test, which is a little more popular in the courts. It's one of those nuanced legal balancing acts that everyone loves. Basically, the court has to discern the center of gravity of the transaction the trustee or the foreign representative is seeking to avoid. Once that center of gravity is determined, the court applies the law of that forum. Because it's less clear-cut, this test gets a few extra slides. This center of gravity test has gotten a lot more traction in bankruptcy courts. Multiple cases have used it to determine choice of law issues. There is a long list of cases, but the one we are going to discuss in the interest of time is Maxwell Communications Corp. PLC. It is an important case for Chapter 15 choice of law generally, and it considers many of the issues that we're going to discuss. The Maxwell case began when Maxwell Communications Corp. Initiated an insolvency proceeding, and in the 90 days before Maxwell filed in the U.S., it repaid the principal on loans from 3 different London banks. Under U.S. law, the foreign representative would have easily been able to recover a substantial amount of money, but under U.K. law, that victory was not as clear. The court stated, among other things, that the traditional federal choice of law rule is to apply the law of the jurisdiction having the greatest interest in the controversy. The court went on to explain that a fact-intensive approach is required, and you have to evaluate the relevant context and make a determination based on all of the evidence. Actually, Professor Westbrook, the law of the forum proponent, was an expert witness in this case. He came in and testified that they should apply UK law. And actually, the bankruptcy court found that under either test, even what they called Professor Westbrook's more radical one, UK law would apply. The district court reached a similar conclusion, and the circuit court affirmed. However, the circuit court placed much more of an emphasis on the question of connection to and interest in the proceeding. And after seeing Maxwell label the law of the forum test as radical, it seems as though the center of gravity test is on the rise, and it shows in the number of cases that choose to apply it. However, ironically, which test will be used depends on the law of the forum in which you choose to file. So now I'm just going to move on to some questions for our panelists, and I hope that it will be an edifying discussion. So let's start with the foreign representative, because this is a really central player in Chapter 15. We've just heard a little about Chapter 15, and I just would like to know more about the main role of the foreign representative in avoidance actions. I know that Ms. Hartley has said that she's worked with foreign representatives before, if you have thoughts on.
Sure. In general, certainly you've got foreign representatives who are able to come to the U.S. and utilize U.S. discovery procedures, which are very helpful and are able to obtain, information that they may not be able to obtain in their, what I'll refer to, I guess, their home country. So It depends, I guess, on what the foreign representative is doing. If it's representing the debtors who are trying to reorganize in their country, then certainly it has a different goal, and it may be coming here to protect assets that are located here in the U.S., to stop, to stay, have the automatic stay come into effect because there's pending litigation here that's disrupting their reorganization process, as well as they may want to bring actions here as well. I'll mention another case that David was also involved in, which is Mt. Gox, and that might ring a bell with some people, but this was the Bitcoin Japanese exchange, and interestingly enough, the backup servers were in Dallas, so they were able to establish, jurisdiction here, and they commenced a Chapter 15 ancillary proceeding. A large percentage of the depositors were U.S. citizens and located here. The debtors wanted to set up a claims process that would be fair, for them here in the U.S. Unfortunately, the principal got indicted. And so in the Japanese proceeding, it quickly turned from a reorganization process to a liquidation, and a trustee was appointed. Once the trustee was appointed, they had no interest in being here in the U.S. And actually dismissed the Chapter 15 proceeding. Under Japanese law, which I'm not familiar with or profess to know, but apparently you have to actually show up and be present to assert your claim. And so, of course, now it was going to be very difficult for those in the U.S. to do that, which, might have been beneficial to those in Japan. So that just gives you, a practical sense of maybe what, happens in some cases. But you also have foreign representatives that act as Chapter 7 trustees or liquidators and are coming here also, to protect assets that are here and also to pursue perhaps potential targets.
I'll give this up to any panelist. If you wanted to use U.S. avoidance law, what are the best ways to do that, and what are the financial considerations? I know you talked about the financial considerations of having to go to Japan and litigate there, but so say you wanted to apply U.S. avoidance law. I know that part of that is actually having to file a U.S. bankruptcy case, like full Chapter 11.
Right. Once a foreign representative files a Chapter 15 ancillary proceeding and is designated as the proper foreign representative, under Chapter 15, that foreign representative could then commence a proceeding here under Chapter 11 or Chapter 7. So that would be the best way to able to fully utilize everything the Bankruptcy Code has to offer and proceed with a lot of the avoidance actions. In Chapter 11, as many of you know, it gets very expensive. And so certainly, the debtor would have to have the financial wherewithal to sustain that process.
So somewhat relatedly, how do non-bankruptcy fraudulent conveyance laws factor into decisions about where to file? Or do they at all? Do these provisions come into play?
Well, I think it goes back to, I guess, the law of the forum, or what the court is perhaps going to apply. Certainly in the Condor case, they were able to use the Neves laws for avoidance actions. Certainly, again, if you know your jurisdiction or whether they look at the center of gravity test or the law of the forum test, might help you in where you decide to file if you want to utilize certain countries' laws and whether you'd be able to do so.
So let's turn to a discussion of the debtors in these Chapter 15 cases. Ms. Bordy, can you tell us a little bit about representing debtors or what the debtors' interests are in these cases and how and if they are aligned with any other parties in particular and maybe some obstacles that they face?
Sure. I mean, I think one of the biggest things is, as we were just talking about, where do you file and how do you make the decision about where you're going to file your main proceeding or your U.S. proceeding? And that's, when you're advising a company, that's really the biggest thing that you're going to spend the pre-petition period talking about. So at Kirkland, we do a lot of these big international cases. We're very lucky to have lawyers all over the world, but we spend, 100 hours with the client sort of talking about, do we need to do a US Chapter 11 because there is an avoidance action that we want to be able to pursue, or not just an avoidance action, we want to be able to reject contracts, or we want to be able to, really have the automatic stay, whatever the benefit of the Chapter 11 proceeding is that you want, versus, are there assets in another country that we're not going to be able, that we don't actually think are going to be protected unless we file a proceeding in that country? Now, do we have 2? Do we have 3? Do we have 4? And I think as we start to get more and more multinational corporations, we are going to see more and more of these proceedings that are maybe, being pursued on a parallel or even 3 tracks at the same time. I was advising a secured lender. I know we had a debtor question, but I was advising a secured lender, and they were a French company with a U.S., very big U.S. presence. And so typically what we would do in that situation, we would just file in the U.S. and maybe leave the foreign, entity out of the filing. Well, in this case, we needed the foreign parent, or they needed the foreign parent to be in a process because there was a lot of debt at that foreign parent level. So what they ended up doing was filing a French proceeding, which was recognized in Chapter 15 in the United States of the parent, and then a U.S. Chapter 11 proceeding for all of the subsidiaries. So the 11 and the 15 were proceeding at the same time, and then there was the French proceeding that was going on itself. So, you have to think about those, and this is not specifically about avoidance actions, but it can be, because one of the things that you might think about is, I've really got a lot of litigation that I want to be able to bring, and so I want to bring it in the U.S., but maybe I'm not allowed to file this entity in the U.S. based on the other country's law, so you might have to combine things together.
Can I actually
Yeah,
make
absolutely.
a pitch for thinking about foreign jurisdictions in this context? I think that as U.S. insolvency lawyers, we often think the automatic stay is worldwide, which I understand it is, but courts in other countries sometimes resent being told what to do by the U.S. Congress. So I think it's important to remember that you do sometimes need these foreign proceedings, either a recognition proceeding or a plenary proceeding, for very simple things like enforcing the automatic stay and making sure that people don't go after the debtor's bank accounts, or even things like their stock. I had a proceeding where we did a recognition proceeding in Canada, and we had a Chapter 11 in the US. And there was a shareholder that was trying to call a shareholders meeting and change the board and stop the Chapter 11 proceeding. And because we had a proceeding in Canada, we were able to go to the court and get the stay enforced. If we hadn't had that, I'm not confident that we would have been able to stop the corporate process in Canada. And so I think this is my plug to remember that foreign countries really do matter.
Well, thank you so much. It's always good to have, a broader perspective, especially as we, like I said, as we've said, as multinational companies grow and continue to seek this sort of relief. So turning to the creditors, I know we started talking about secured creditors and note holders. Scott, what are the major issues that creditors face in these types of actions?
I wasn't prepared to answer that question. From our perspective, and my role playing as note holders, is the debtors are always trying to screw the note holders. And not specifically Kirkland, but there's a lot of gamesmanship around this type of international drama. I'll give you a couple of examples. You would think that there'd be comedy between England and America. I did not have a foreign proceeding. I represented a debtor in the US. So I'd have to go to the bankruptcy court to get an international TRO, query whether that's even enforceable.
Funny how foreign countries feel about being told what to do.
Yeah, just a non-life 10-year bankruptcy judge,
Yeah.
Judge Deal, that you are now enjoined and you can face sanctions. And it really presents, particularly if the company can't support all these proceedings all across the world, how to kind of rope in all these jurisdictions and telling judges in other countries that they have to respect U.S. law. But we're representing note holders, where I think the hanky-panky, for lack of for the use of Latin, I kind of veer towards the center of gravity test, in the sense that, coupled with maybe a modification, the creditor expectation test. So, as some of you know, with ordinary course transactions, there's a horizontal and there's a vertical test. And the vertical test is, has the company done this in the past? The horizontal test is the creditor expectation test. So the way I viewed this is, and I'll give you an example, we had debt, about $650 million in debt issued from a Nova Scotia company. And the interesting thing about the tax structure is, in order to get IRS not to recognize the income from Canadian bonds, it has to be an unlimited liability up in Canada. So one of the interesting things in the Abitibi-Bowater case, where I represented the bondholders, is fine, let the U.S. proceeding go. There's a Canadian cross-border protocol. The bankruptcy judge in Delaware, in this instance, basically signs a self-affirming order. I get to determine claims. Nothing impinges upon my jurisdiction. But where it gets weird, and particularly in this case, is we had Canadian bonds issued by an unlimited liability Nova Scotian entity. So my bondholders, and by the way, these are the folks you would think, they're not retail mom and pops. They're the guys who buy on the secondary market from the mom and pops, because there's a vig associated with buying at a discount and then demanding par. So getting beyond the altruism of buying on the secondary market, these guys were looking at the bonds and like, okay, they're unlimited, they're under Canadian law, they're Nova Scotia, the guarantee is unlimited, because in order for Bowater to get the IRS not to recognize income associated with a business acquisition, income as a result of Canadian operations, that had to be an unlimited liability in Canada. So what we said is, great, query whether this was a mistake, is we don't care about the US proceeding, we're just going to proceed in Canada and go after our bond. And it was actually two claims. It was the Wilmington Trust indentured trustee claim plus the US guarantee claim. But where it gets weird is, even though that entity didn't file in the US, it wasn't a US debtor, it was a Canadian debtor, is Judge Shannon in Delaware gets offended when you do stuff outside of the US.
How that works.
So, and Judge, you know exactly what I'm talking about. And so it gets, we thought we had a hook because it wasn't a US debtor, let's go to Canada. But then we had to file a claim, right? Had to come into the US and file a claim against the guarantee. And this is where, you know, from my client's perspective, they're getting screwed by the debtors, because they're using different jurisdictions to force you to come into the US as opposed to staying in Canada. But that, of course, was a conscious decision. We knew that the leverage that we'd recreate by doing it in Canada would cause leverage on the guarantee. So a skeptical in litigation view is that the US debtors are looking for a reason to screw us, but it's also, from people that buy on the secondary market, it's leverage.
Well, that ULC play has actually been used a couple of different times. So for people who aren't familiar with this, a ULC is a unusual form of corporation that exists in certain jurisdictions in Canada, and the bottom line of it is that the parent company is on the hook for all of the debts of the company. So anytime that the ULC has claims it can't pay, it can look to its parent and say, you gotta pay me so I can pay my creditors.
The winding down claim,
Yes,
you gotta pay for
the wind-up
yeah.
claim. So it's a unique form of company. It was used a lot for tax purposes. I'm not a tax lawyer, but my understanding is that a lot of those benefits no longer exist. But it's been used a couple of times in these restructuring proceedings, in the Abitibi proceedings, in the General Motors proceedings. There was a similar claim made. Again, kind of trying to game the jurisdiction both times to mixed results.
And the interesting thing is, on the M&A side, representing U.S. entities that want to do deals overseas, Canada, Spain, where have you, because of these international compacts and between states, you have to set up the foreign entities in a way that you wouldn't set them up in the U.S. So in this instance, my altruistic clients who bought the Canadian bonds look at the ULC play and go, well, we don't care what happens in the stinking U.S. bankruptcy. And it's far more complex, and I think after that case, U.S. debtor representatives would often then remember to make the U.S. debtor also a Canadian debtor to avoid this kind of
Game playing on the
not game playing, I mean perfectly appropriate high-level litigation strategy.
You know what I will say, given the side I was on in the General Motors case, it was perfectly appropriate.
Yeah, that's right.
Actually, what we were just talking about reminded me of I think something that's gonna be a more prevalent thing coming up in cross-border proceedings, which is where is the comey, right? Like where is the choice of law gonna, where is the center of gravity going to be? I think that as companies get more sophisticated, we may start to see a little bit of forum shopping, kind of the same way that Delaware became a huge haven for corporate bankruptcies. Query whether countries are going to try to become restructuring havens. The Marshall Islands, maybe the Cayman Islands. These are places that are starting to pitch to international companies. Come here and you can do whatever you want to do to restructure. And there may be situations where the debtor relocates their center of main interest, relocates their comey in order to file a bankruptcy case in that jurisdiction. And you may have, maybe a battle between the creditor who's now subject to laws that they did not expect to be subject to. Maybe those are avoidance actions. Maybe a country says, we're gonna put in like the most aggressive avoidance actions you could possibly imagine, where you can go out and get money from creditors 5, 6, 7, tiers down the line if you come and file here. And debtors say, well, that's great. I can get this protection of the code or whatever, they put in place, and I can go and get a bunch of money into my estate. And the creditor goes, wait. When I lent you money, I lent into a American entity. I lent into a Greek entity, whatever it is. And now all of a sudden you're a Cayman Islands entity. I'm picking on Cayman Islands, but and then you start to have these fights about, well, does comey mean the comey on the day that you filed for bankruptcy, or is it a more historical look back over 5, 10 years, the creditor expectations test, stuff like that. We were involved as creditors in a bankruptcy proceeding where that was potentially at issue, and we ended up settling with the debtor, but that could have been a huge fight because they relocated exactly to the Cayman, which is why I'm using that example. I think it was something like 6 months before they filed, they started moving stuff. They had an office in the Cayman Islands, but it was just a rental that was shared by like 5 or 6 other companies, so basically a P.O. box. The principal of the company had a cell phone in the Cayman Islands, and he would rent a vacation home there. And they said that was their comey. And we were about to fight with them and make that a big argument and say, no, that's not your comey, because Cayman Islands much more friendly to cramming down on minority positions than the U.S. is.
And so, if I can, because of the tax play in international M&A, a prior company that I was with, we deliberately set up an entity in the Netherlands, and as our office was a law firm's office who helped us set it up. But to kind of meet that threshold, now this is a well-capitalized company, so it's not an insolvent company, but one of us officers, once a year, we had to fly It wasn't actually bad, other than, you fly into the airport and you fly out. But that's a tough flight because the Netherlands law required us to have a physical presence. And it just happened to be at the law firm. It wasn't a cell phone, it wasn't a P.O. box. And what you'll see is, and I know you've seen this too, is that when you peel back the layer of the onions and you're playing in the secondary market and you go, okay, now I own a position, I have a blocking position in this debt, this foreign debt, let's look at not that they don't do their due diligence, and then after they buy, start looking at the corporate structure, but no board meetings, no officers and directors, no physical presence, and you start to see this veil piercing type. You guys are familiar with the veil piercing and instrumentality and fraud in the inducement type thing. Putting aside the fact that if you buy after the supposed fraud occurred, whether that's fraud in the inducement, but you start to see these veil-piercing factors, like whose interests are you working for? What are you doing to wind down a Canadian company to satisfy all the liabilities, to satisfy the ULA? Well, and you start getting into these what appear to be shams. And that's where the litigation and the leverage, and this stuff gets litigated all the time, simply because people aren't following the formalities, or they move the assets within 6 months to the Cayman Island. Well, what fraudulent transfer law applies, but let's go to the US to make sure that we preserve that claim. There's a lot of, the formalities are not filed. The company always says, oh, it's to preserve the tax benefits, but a more skeptical creditor might think otherwise.
Actually, just to add on, foreign companies or foreign representatives are doing sort of a similar thing in reverse. You need assets here in the U.S. To establish the Chapter 15, perhaps, and a bank account would be sufficient. But even if you don't have that, just sending a retainer and hiring a law firm here in the U.S. meets that requirement. A lot of courts have held. So they're able to establish Chapter 15 jurisdiction here by simply retaining counsel.
Now that works both ways. Yep.
Even Chapter 11 jurisdiction, right?
Yeah. So in Chapter 11, I'll get calls saying, hey, can you open up a Wilmington Trust bank account for this company that has nothing other than a bank account? And it gets into a whole series of other issues as to, and the Russian Gazprom tried that in Houston, and I believe the Houston judge bumped it out because it was a retainer, a law firm, Vincent & Elkins retainer or something like that, and they said, we're in the U.S., and the judge didn't buy that.
I think, though, one of the important things to think about is, even if you're able to file your proceedings and get a judgment in one of these other jurisdictions that has the crazy laws that you're talking about, when you actually try to go enforce that judgment, you're going to have to deal with the laws of the jurisdiction where the assets are located. I think if you came to Canada and you tried to enforce a law that was, or tried to enforce a judgment on the basis of a law that was just bonkers, to use a legal term, I think you'd have a really hard time getting that order enforced. Even if you have a recognition proceeding going, there are provisions that say the court doesn't have to recognize anything that's against public policy. And there's actually even decisions that say if the order is going to be, hold on, I underlined the words for you, whether there is any material adverse interest to any Canadian interests. So if the court thinks that what you're doing is really particularly unfair to Canadians, you just may not get your judgment recognized.
And it presents, personal jurisdiction issues, discovery issues. Our default is always go back to Mother May I being the bankruptcy court in Delaware, and try to enforce this, but then well, how the heck are you going to get jurisdiction over somebody in Belgium? And I got this order. Well, the Belgian, you're not going to get right. You're not going to get a Belgian court to enforce that. And particularly in the fraud cases, Mark and we were talking about dinner about fraud in the L&H case, where people just disappear. Well, we can probably find them, but how do you get them arrested? How do you can't get worldwide injunctions. There's all kinds of limitations on the remedy. Yeah. Congratulations, you got this great judgment, but now how do you enforce it?
What do you do with it?
Well, I think we've talked a lot about some interesting facets of Canadian insolvency law. Ms. Levine, if you wouldn't mind just talking a little bit more about that, and just because it's so close. I mean, it's right there. Can you talk a little bit more about the Canadian Insolvency Protocol and how it interacts with U.S. law?
Sure. So here's my 2-minute primer on Canadian insolvency law. There are sort of two main statutes that we use for restructurings in Canada. The first is called the Companies Creditors Arrangement Act. That's what you use if you have a big company, generally, if you need to restructure. You need to have at least $5 million in liabilities. The other statute is called the Bankruptcy and Insolvency Act. The Bankruptcy and Insolvency Act is also available for restructurings. Often we see it really just in a straight liquidation context. So if you were filing the equivalent of a Chapter 7, you'd do it under the BIA. There are Chapter 15 provisions in both the BIA and the CCAA. I know of only 2 recognition proceedings that ever occurred under the BIA. There are probably more, but only 2 that I sort of know of off the top of my head. More often we see them under the CCAA. The recognition provisions in the CCAA are called Part 4. They're very, very similar to Chapter 15, but we don't have all that many of them these days. We did have quite a lot of them right after the provisions were added to the Act. I want to say it's 2009, but I should have checked that one before I started talking. So we did see a number of them right after that. We've seen fewer in the past couple of years. I think just because we're struggling with some of these issues about how do you make decisions that are going to affect large groups of people, decisions that may have really significant impacts on Canadian stakeholders, and whether or not it really is appropriate to have those decisions being made in a foreign jurisdiction. So the quote that I read you before about whether there's a material adverse interest to a Canadian stakeholder, I think that's really been the guiding light for the court on a number of the recent cases. And so when you have big issues that involve things like labor unions or employees or even landlords, who are often big creditor constituents, the question becomes, is it really fair to make those significant stakeholders subject to the rules in a foreign jurisdiction? Is it really fair to make people who thought that they were bargaining under one set of rules go to a court in a foreign country to seek the relief that they are entitled to? So we do still see these recognition proceedings, though I was actually just saying to Judge Deal before, I actually think we may see more of the sort of dual plenary proceedings. That's what happened in Toys R Us. That's what happened in Payless. I think we may see more of those.
And then the courts typically set up a protocol where they'll communicate with each other and they'll kind of say, we will either sua sponte or according to some rule, have a weekly check-in or a monthly check-in or send each other letters or something like that, and they just talk to each other.
Or as needed.
Or as
Perhaps
needed.
the council are able to coordinate and there's never a need for a joint hearing. But it's usually something approved at the first day in both hearings and sort of sets up a protocol from the beginning about how are we going to deal with issues where there's a conflict of law. And I was totally looking at your...
Yeah, no, this was interesting. I had a case in Texas, so I'm on the, I get the notices from the court. And so this just came out January 31st, 2019 from the United States Bankruptcy Court for the Southern District of Texas. And it was an order, and it says, by unanimous vote, the court adopts, as may be amended from time to time, the guidelines for communication and cooperation between courts and cross-border insolvency matters, and then defines the guidelines and then issued some guidelines.
I helped read those.
I'm
was
curious because there are new guidelines that were just adopted. I think these are the new ones. There are new guidelines that were just adopted by what's called the Judicial Insolvency Network. And so I know New York and Delaware have both adopted those guidelines and directed them to be attached to cross-border protocols. The same thing is true in Ontario, not actually officially by practice direction or anything, but there was a notice sort of sent out to the insolvency community saying the court is expecting to see these new guidelines used.
And these can be really impactful on the process of a case. You might say, oh, this is just an informal communication between two courts, but they can really change the direction that a case is going or how the debtor or the creditors think they're going to be able to try to pull a fast one on one judge or the other. And when you have these communication protocols in place, the courts will talk to each other and they will, ensure that one is not being, it's not mom and dad being played against each other for the pony. And I've actually seen that happen where the court has either written a letter or called up and said, this creditor is trying to do something in my court. Is that in conflict with what you're doing there? Or are they coming to you and telling you about this as well? And it can really be detrimental to the creditor that tries to play favorites with one court or the other.
I also think cross-border protocols, not necessarily the GIN guidelines, but the order that would govern the GIN guidelines and the protocol that is usually developed in the case can be really helpful at just establishing the ground rules. So on things like a claims process, if you get in your protocol that we're going to work together and we're going to establish a joint claims process, it makes clear that one court's not going to get out ahead of the other one and start running a claims process where the other court then is left trying to catch up. And the creditors in that second jurisdiction are somehow prejudiced because they're not part of the claims process.
In the U.S., that's a claims process.
I was going to say, I could translate for you if you need.
So as we get closer to the end of our time, I just wanted to ask about, I know we discussed a little bit about how certain jurisdictions are changing their laws or changing their rules to incentivize companies to move their center of main interests. But is there, other than just full-on venue reform, is there a way to incentivize Chapter 15 filings in different jurisdictions than the main two, or are we just stuck?
The main two being?
Delaware and New York, and then of course a little bit of the Fifth Circuit and Texas and Mississippi, and Florida. So I know that, but is there like, what does the future of Chapter 15 look like? And just a few thoughts on that would I think be interesting.
I mean, I think the reason that you see those cases filing in Delaware and New York is the experience of the judges on those matters, right? Because they've just seen more of them. And there are efforts by judges around the country to try to drive not just Chapter 15, not Chapter 15, but Chapter 11s to those districts. So I don't know how many of you are familiar, but Texas has instituted basically these complex bankruptcy rules, and they've elected 2 of the judges to serve as basically, if you file a big complex Chapter 11 case, you're going to get 1 of 2 bankruptcy judges in Texas they have a business background, they have a complex bankruptcy background, and so you kind of are guaranteed to have somebody who understands the needs of a complex Chapter 11 large debtor case. So that's an avenue, right? You could have courts around the country say, we want more Chapter 15 work, and so we're going to establish 1 or 2 judges in this district who are going to be really knowledgeable about Chapter 15 issues, who are going to be ready to take Chapter 15 cases. But I think the reason you probably don't see more of those is that these companies that are seeking to have Chapter 15 recognized in the U.S. don't have a huge U.S. presence. So there's not really a reason where in the Chapter 11 venue shopping issue, you have an issue where you have, a Michigan company that's filing in New York, and the Michigan creditors are saying, well, why are we having to go to New York? If you're having a Chapter 15, you already have the presumption of not having a U.S. presence, and so I don't know that there's as much of a need to have a development outside of New York where the financial markets are, so a lot of the creditors, if there's going to be international lending creditors are going to be there, and Delaware where you have the corporate center.
I absolutely think there is a future for recognition proceedings. I think there is definitely going to be a need for them. I think that need, to the point that you were just making, is perhaps more limited, that in an effort to save money and in an effort to be efficient, maybe we had thought before we could use them for more. But I think that people are deciding there is sort of a specific use for recognition proceedings, and it's going to be where the center of main interest really is clear one way or the other.
on venue, folks from Delaware don't talk about it much because we're often criticized about it. And when advising debtors, this is a kind of a market approach. I have filed debtors in Columbus, Middle District, and in Houston under the complex, and the judges have been fantastic. I think there is a business bias and almost reflexive. You got to, especially in Chapter 15s, you got to file in New York, and it's often hard to get boards or managers to get off that bias because they've heard of those reputations. But my personal experience is I've been in a lot of jurisdictions outside of Delaware, and the judges have always been very good.
We've seen several filings in Miami for Chapter 15. They're not the restructuring type, but more the foreign representative is in a liquidation capacity, sort of Chapter 7 trustee, and is really filing here to get more discovery or to try and attack U.S. companies or U.S. Citizens that are living here that they feel received fraudulent transfers. So there's 2 currently pending. So from Brazil, I don't know if it's proximity, why they're, selecting Miami, or, but we're seeing a number of Brazilian Chapter 15s.
They do it so they can boat, right, in Biscayne Bay.
I did have one Chapter 15 that we actually filed in Alaska because it was a Yukon company, and we had some assets that were in Alaska, so the Chapter 15 got filed in Alaska. And the judge actually said at the beginning of the first day hearing that he had really hoped to retire before having to figure out Chapter 15. So he was really annoyed with us for ruining that plan.
Well, on that note, I'm so thankful for our panelists today and giving us insight on a complex and rare but growing area of the law. Thank you so much, and thank you everyone for being here at this symposium. Thank you so much for coming. Thank you to Judge Deal for an inspiring address, and thank you to our consumer panelists as well. Thank you to everyone for coming, and let's give our panelists a round of applause.
I'm happy. I'll send you. I sort of
And with the conclusion of this absolutely fantastic panel, thank you again. I would like to invite each of you, and I hope that you will join us for a lunch out in Hunter Atrium. Before, however, we sprint out the door, I do want to take one moment to thank Jake Reisner, our Executive Symposium Editor, Maria Valderrama, our Symposium Editor, and Rhonda Heermans. Without these editors and the culmination of the planning and the months of work that they put into the symposium, we wouldn't be here today listening to the incredible things that we've heard. So without the tireless work of these editors, it would have been impossible, and I want to take a moment to thank them. Thank you, Jim.